Welcome back to Unfair Housing. I'm Alicia Magazu. It's great to have you back this week as Nicole and I finish our discussion with civil rights attorney John Relman on modern-day redlining practices and reverse redlining. Last week, John shared the work he's done combating redlining practices. He also raised the issue of how redlining created an environment for reverse redlining. Neighborhoods historically cut off from traditional home loans through redlining practices became a thriving market for predatory loan products and predatory practices, much like we discussed in previous episodes regarding contract sales. Here's the rest of our conversation with John.
I find that really interesting to kind of go from our historical context, and we do tell our listeners a lot of the times passing a law doesn't always change behavior, and even now it still hasn't changed behavior as you're helping describe, but what it has done is given advocates tools to be able to prove these points, and kind of generally accepted tools that we can use to now prove these points and put them right in front of people's faces and say, look, the disparity is stark, it's right here. It's really, really neat to hear. And kind of on that same note, like we were talking about the contract sales and the land contract sales and things kind of, there being laws in place and you kind of assume that changes outcomes. Have you seen issues with contract sales in more modern times, or is that an issue that is a thing of the past?
No, it's not. And in fact, we had a case in Indiana that focused on this very issue. It was one type of predatory practice. It is not, I would say, the most common of the predatory practices, and I can talk about some of those predatory practices that form the basis for this targeting of minority communities or reverse redlining, but it still does exist. In this case in Indiana, what we saw was that it was a mirror. It was almost a duplicate of the old time practice of these land contract sales. What happened was that Rainbow Realty, a company out in Indiana, what they were doing was they were identifying properties that were almost uninhabitable in Black communities, that homes that had been abandoned, that had huge habitability problems, and they would buy them up for a small amount of money, $10,000. And then they would turn around and they would sell them for exorbitant prices. And they featured it as, they said it was a sale. They talked about it. They marketed it as if you were purchasing a home. But in fact, in the fine print of the contract, you were not getting equity in the home. There was an initial, what was called purchase agreement that was not a purchase agreement. It was in effect a rental agreement. And the way it worked was for folks who were, again, desperate for housing in an underserved Black community, they would pay first an exorbitant price, and they would be told you're paying an interest rate as if you are buying a home. But in practice, what was happening was that for the first 24 months, you had to make what in the fine print was a rental payment. You didn't have any equity in the home for those 24 months, no equity whatsoever. And it expressly said that unlike a rental, where the landlord has to make sure that the housing is habitable, that the repairs are done, that it's meets code. Here, the contract said you, the so-called purchaser, quote unquote, you have to pay for all of the repairs. But in the fine print, what happened in practice was if you were late in those first 24 months, one time for a payment that was effectively a rental payment, you would default to an 18%, a usurious rate interest payment. And when you couldn't make those payments, you could be evicted in a landlord-tenant court. Now, that's significant because there are benefits to homeowning, and then there are downsides to homeowning. The benefit for homeowning is you build equity, but the downside is you have to pay for all the improvements. So you got to pay for the improvements. And one additional benefit is the process for losing your house is long and involved. Foreclosing on a property takes a lot, and there is a lot of notices and a lot of legal process. The flip in the landlord tenant market for rentals is the advantage for the renter is that the landlord has to provide a habitable property that meets code. But the downside is that if you don't make your rent, the eviction process can go quite fast, and it's set up to do that. So in this case, what Rainbow was doing was they wanted all the benefits of home ownership that were good for them, meaning they didn't have to pay for the improvements. They retained the equity in the house if you did not make payments for the first 24 months, and they could at the same time they got all the benefits of being a landlord because they could evict you quickly. They didn't have to go through the foreclosure process. Meanwhile, the buyer, so-called buyer or tenant in actuality, got all of the bad problems of the landlord tenant process and none of the benefits of home ownership. They would essentially, in the first 24 months, if they were late, they would lose the property quickly. They would have no equity in it, and they would have paid for all the improvements that had been done, and that would all go to Rainbow. So again, very predatory practice that was targeted at Black communities. And so that was a continuation of an old time practice. In modern times, those practices have now changed and become even more sophisticated. And these practices that are ones that we first saw in what I call the modern era of reverse redlining.
John, earlier you used the phrase peddling poison, and that's definitely what's coming to mind as you're describing this practice by Rainbow Realty. If you're able to, what outcome occurred in that case?
In that case, we got that practice stopped.
And so it sounds like there were many similarities between the cases we discussed in our previous episode on contract sales and the actions taken by Rainbow Realty. What are some of the nuances that make modern day reverse redlining different from past redlining practices?
In the modern era, what we have seen more typically with reverse redlining is what started with the Hargraves case in 2000. And there, what we saw was sort of a natural continuation of the redlining process. So in the 90s, what we had was people either qualified for a prime loan or they didn't qualify for any loan at all. You either had to have A credit, think of it that way, or you couldn't get a loan. You fell off a cliff. You just were denied. Like in the case of Professor Boyer, that was discrimination, but they were saying you don't have absolutely perfect credit, so we're not going to give you a loan. What happened in the late 90s and early 2000s was that banks started to experiment with something called risk-based pricing. They said, you know what? We could make what we call subprime loans to folks that have B credit or C credit or even D credit, as long as we charge them more. In other words, think of it as a scale. As the loan becomes riskier, we'll charge you a higher interest rate. And then if we make a combination of loans that are A credit all the way down to D credit, we'll balance out the risk. That practice, in theory, could work. But what quickly happened was, as there was a huge demand for housing in the early 2000s and the housing market started to boom, there were lenders in mortgage companies starting out in California that really started to take advantage of this practice. And what they did was they came in and they charged really high interest rates for folks. They engaged in usurious loans. And for some of them, the practice was not about actually making a loan, but it was about stealing the property, about taking the property. And we saw that in the Hargraves case, which was one of the first ones, where there was a company called Capital City Mortgage in DC that specifically targeted houses with high equity. Those folks who had not much in the way of a lien or of a mortgage on the property. So they had a lot of equity in the property. And they really looked for people who they thought probably would not be able to pay, convinced them to take out a very high balance loan, And then as soon as they couldn't pay, in the case of Capital City Mortgage, they had a default interest rate that went right up to the top that was allowed in the district, which was 18%, which is actually a usurious rate, and was actually not allowed in the district, I should say. And then would go ahead and foreclose on the property. And they would, at foreclosure sale, they would then buy the property at a very, very low price and then turn around and sell it again at a much, much higher price back on the market. That's what's called flipping the property. We saw that also with a company called Emigrant Mortgage Company that we brought suit against in 2016. They were doing that in New York City, and they were actually looking for people who had low credit scores. And they had made a product that was called the Star Nina loan, and they offered it to people with credit scores below 600, and they deliberately did not look at their income or whether they could pay back. They simply looked at whether there was a high asset or high equity in the property. And it's sort of like what's called asset-based financing. And they literally stole the properties from people who had hundreds of thousands of dollars of equity in their home by, once again, having a default interest rate that went to 18% if you got behind on one payment. And of course, people who are bad credit risks, they in turn, are likely to get behind. And so you set up a scheme that they hid in a rider to the contract to make sure that they did get behind. The key thing about Emigrant, the key thing about Hargrave's case, both of them, they're 16 years apart, but they're identical, was that they targeted communities that had been historically redlined, Black communities, for these practices. And in the case of Emigrant, we tried it to a jury and won a decision where the jury found that Emigrant had targeted Black and Hispanic communities in New York City. We showed through the marketing that they had used and the newspapers that they had advertised in and how they'd gone about doing their marketing. In the case of Hargraves, we pointed to the network of brokers and runners that Capital City Mortgage used to go straight into the Black community and make sure they identified people who they thought they could steal properties from. Now, in the Hargraves case, that was in 2000, and it was in that case that Judge Joyce Green issued one of the first rulings to say that if you target a neighborhood for a poisonous product, that violates the Fair Housing Act just as much as if you deny a good product to a neighborhood because of its race. And in that case, she pointed out that, look, if you use a poisonous product, you're essentially taking the property away from people. And her point was that's making housing unavailable, and that is strictly prohibited by the Fair Housing Act.
So this theory of reverse redlining, obviously hugely helpful in housing cases. Have you had success using it to address other civil rights injustices as well?
Yes. Probably, the first case where we pivoted away from housing was just after we had finished with the cases against Wells Fargo. The Wells Fargo cases were typical of the reverse redlining. They were also in housing, and it came about in 2008, 2009. And what Wells did was they targeted minority communities for predatory loans that people didn't need. And that were at high interest rates. They made a lot of money at the time of closing. They then sold it on the secondary market, and these were dangerous loans. But when they sold them on the secondary market, the banks that bought them, when the housing market crashed, they went under because so many of those loans people couldn't pay that literally precipitated the crisis that we saw Bear Stearns and other banks, Deutsche Bank and others, having huge calamitous problems, and contributed significantly both to the collapse of the housing market in 2009 and to the subsequent racial wealth gap that we saw, because Black homes that were targeted lost so much household wealth out of the fact that they were losing their homes to foreclosure, compared to white homes. Right after that, though, a case came in the door that involved something called the Richmond School of Health and Technology. This was in 2010, 2011. And what was happening there was Richmond School of Health and Technology was a vocational school. It was based in Richmond, Virginia. And what they were doing was they were supposedly providing education, vocational education, for people who wanted to be physician assistants, to be surgical assistants, to be nurse practitioners, and so forth. And said, we will give you instruction and we will prepare you to pass the certifications in the state of Virginia. In fact, their education was a total sham. The teachers didn't show up. They did not have enough books or provide internships that were required to get the students accredited. In many cases, the accreditations that they said existed did not exist for the practices they had. And so students had no chance of passing and getting any sort of professional advancement. At the same time, what they were doing was they were going to the Department of Education and helping these students to qualify for Department of Education Pell Grants and loans. And it was these loans that they got these students into, which they were charging huge prices for these courses that were doing nothing for the students, where the students had no chance of getting any benefit from. And yet they charged $28,000 for a supposed course, and they would use these Pell Grants to fund the tuition. So it was like they were going and taking federal government money that was designed to help students for legitimate education and using it to finance their sham transaction. For the students, they would end up way in debt, no chance of ever getting certification or getting a job. And they ended up having their credit ruined. So it was an absolute disaster. But on top of that, and we learned about this practice from ex-employees at Richmond School of Health and Technology who came to us and talked to us about what was happening, what they saw what was happening to scores of students. And in that case, when we started to explore, we found that it was the Black neighborhoods and the underserved neighborhoods of Richmond, Virginia, that were being targeted for these school programs. They were told, "Come on in, you'll get a job at $75,000 a year. This is a great thing to do. It's a no-brainer," and so forth and so on. And it was targeted at these Black neighborhoods. We ended up filing a class action, and the case settled with approximately $5 million of relief for a class of students who got money back on what they had lost, and essentially shut down the Richmond School of Health and Technology and forced them to reform their practices. We had a similar case against Walden University that settled just last year for $28 million for a class. Similar practices, not so much the sham education, but a deceptive practice that got students enmeshed in essentially a deceptive practice about the credits that they needed to graduate and kept them in a trap where they could never finally get the credits that they needed to graduate, what were called these capstone credits. And each time they were told they had to get another credit, another credit, another credit, they had to pay more and more money for tuition. And that practice, again, targeted at Black communities that ended up settling for $28 million in money that was paid back to these students. So, and the Wells Fargo case was a housing case where when the Justice Department came in, that case settled for over $200 million of relief across the country. We brought that case on behalf of actually the cities of Baltimore and Memphis. But again, significant relief in these cases. I think, though, it was more the exposing of the practice that was the significance of these early cases, to let people know not only are these practices still going on, but they are civil rights issues. These are not just consumer protection violations. These are violations that are or practices that are being targeted at Black communities, specifically because of the history of discrimination in this country.
I have to agree with you. I think that's a very important point to make, and something we really want to highlight with our programming is that this is not activity that is of the past, but the past has greatly influenced the practices of today. And it's interesting, talking about education and kind of other outside factors that have taken wealth from Black communities. A lot of what we've discussed throughout our discussions on the history of housing segregation was things like Black tax and the cost of things being higher in Black neighborhoods without explanation, and other activities such as it's segregation as it relates to education and employment opportunities and that kind of thing. And even though these other ancillary things aren't necessarily housing specific related, what correlation do you think there is between these other discriminatory activities, or do you think there's a correlation that does impact housing and the development of wealth for Black families?
Oh, there's no question about it. Well, I mean, what this boils down to, what everything we've been talking about today really boils down to what we call equity stripping. These are practices where, for private companies, for people who want to make money and see a vulnerable population, they have been able to, because of the practices of historic discrimination, because we are segregated societies, because they can find a community that's identifiably Black. They can go into that community and they can peddle this poison with success. I mean, Wells Fargo is the best example. Ex-employees came forward and from Wells Fargo and literally told us, we deliberately went to Black churches and convinced the pastors there that folks in their community should come see us. And then we sold people loans that we knew they didn't need, that they could have qualified for prime loans, but we gave them subprime loans. Why? Because we made a ton of money. At the time of closing, we made a ton of money, and then we sold the risk, because the bigger the loan and the more points they could put on it, the more money they'd make. And then they sold the risk to somebody else. One of these folks told us, who had been a paralegal at a law firm and had gone to work for Wells and was in charge of this effort. She said, in my first year in commissions, I made $750,000 by peddling these loans. And she was disgusted by it and came forward and told us what they were doing. So this practice is one that literally, when these loans inevitably went into foreclosure because people could not pay these high interest rates, and when the market crashed and these loans went into foreclosure, what ended up happening was people lost their homes. And with these abandoned homes in places like Baltimore and Memphis in the Black community, the value of the surrounding properties dropped significantly, because where you have foreclosed or abandoned homes, it affects the value of the whole neighborhood. And so that is literally why today, when you look at the average household wealth of a Black household and the average household wealth of a white household, you'll see an enormous gap. In many cases, a 7 or 10-fold gap, meaning whites have 7 or 10 times the household wealth of the average Black family to this day. And all of these practices, whether it's a land contract, whether it's getting somebody behind on an unscrupulous loan practice for a education product that doesn't get you anything and destroys your credit, these are all ways of literally stealing money from Black communities, draining money out of Black communities. And that is to enrich a private sector that simply wants to take advantage of anybody that they can identify and take money from. In this case, it's been the Black community. And that's just a practice that's been going on in one form or another since the practice of slavery began in this country, and continuing well after the Civil War, with Jim Crow laws, with government sanctioned redlining, with Black codes, with land contracts, with all sorts of predatory practices that were literally designed to strip wealth out of Black communities simply because companies and governments could. And that's been the unfortunate story of this country And it still goes on today in wherever we're not paying attention, where we don't have good means of investigating or being able to shine a bright light on these practices, where we don't have strong enforcement either from the government or from private civil rights lawyers or from advocacy organizations, it just blooms again. It's something that we have never figured out how to actually confront and eliminate. We have these laws in place, but it takes real vigilance and a consistency to the enforcement effort and an acknowledgement that it goes on. And in so many places, even in the private sector, they show what we hear over and over again is, well, we developed this product because that's where the need was for it, without looking to see whether it's a product that actually takes advantage of people or whether it actually helps people. And whether it's a product that's actually being used in neighborhoods where there, are folks who are white who would supposedly have a need for it, but the practice is not peddled there. And indeed, when we look at Hargraves, cases that were 16 years apart, the products that were developed there to target the Black community, they weren't used in the white community at all. So it really speaks volumes about what is the underlying purpose, what's the underlying history, what's the underlying practice here. It's been for literally centuries in this country about exploiting people based on the color of folks' skin, based on the color of the people who live in neighborhoods.
Which is the enforcement piece. And certainly we see that as fair housing practitioners. It's hugely challenging to enforce. There's so much to unwind and unpack in these sort of predatory practices and bad products. So John, thank you so much for your work and your leadership in this space. With that said, before we end it, I'm curious to know from you what emerging issues you think fair housing advocates should be on the lookout for in 2025 and beyond.
Well, there are a lot of issues. And one of the things that I fear, I have to say, as a sort of a, just a cautionary tale, is that we're right now seeing an evisceration of the regulatory function in this country, the Justice Department being sidelined, the CFPB being essentially shuttered. And so it's a scary moment for those who care about the enforcement effort. And a lot is falling on the shoulders of private civil rights lawyers and advocacy organizations to pick up the slack and make sure that the work that has been done and the accelerating work that's been done by the federal government and by state governments continues to be done. And that said, I'm hoping that the regulatory effort in a number of state governments will pick up now for where the federal government is falling down. I think one of the things that we saw in the last couple of years that's an emerging issue that I would leave you with is appraisal discrimination. And that takes two forms. In the case of individual appraisals for people who want to have their home appraised to get a loan, typically what we've seen, and there's been more and more attention to it in the last couple of years, is that if you're Black, your home is undervalued. In other words, appraisers come in, and if they know that the homeowner is Black, evidence is increasingly showing that the home gets underappraised compared to what its sale value should be. And that means that you can't get a loan. We have a case going on right now involving two professors. They were married. One of the spouse now sadly deceased, but Nathan Connolly, who is the professor we are currently representing, professor of African American urban studies and history at Johns Hopkins, was living in a white community in Baltimore and had his house appraised and thought it was incredibly low, thought something was very much wrong. And he actually did what was called a whitewashing experiment. Now that's something is now increasingly being done by people around the country. And that really refers to a practice where folks who think that their house has been underappraised because they're Black will simply clear out any evidence that in the house, pictures, family pictures, whatever, that may indicate that a Black person lived there. In this case, that's what the Connollys did, what Nathan Connolly did, and asked a white neighbor to show the house to a different appraiser who appraised the house at $270,000 more, um, uh, believing that the folks who lived there were white. And so at one end of at the scale, we see this and increasing statistical evidence that Black homeowners, when they want to appraise to get a loan, are underappraised. On the other side, what we are seeing increasingly now, and studies show, is that when tax assessments are done by cities, we're finding that the models that are being used, or the approaches, the methodologies that are being used, result, and this is a pattern we're seeing in cities across the country, that if you're Black and you're lower income, your house is assessed at more than its sale value. And if you're white and wealthier, your house is assessed at less than the sale value. This is what we call a regressive tax. And this is a pattern that we see around the country that now is rising to the fore. And mayors across the country are asking, why is this happening? Philadelphia, the mayor of Philadelphia right now has a task force that's assigned to figuring out what is going on with the property tax assessment models in that city. This is an incredibly important issue because if you think about it, what it means is if you're Black, when it comes time to get a loan, which would be to realize the equity and take advantage of the equity you've built in your property, your property is undervalued and you can't get the equity that you deserve. But when it comes time to be taxed, you're told your property is worth more than it actually the sales price is, and you're paying more in taxes. So equity be taken away through the tax process and equity being denied through the loan process. It's like, if you're Black, you get it coming and going. And I think this is a huge, huge issue. The Biden administration was just getting going on this issue. They developed an appraisal task force called PAVE. And they were looking at this issue, and they had finished some of their initial work and had passed it on to the different agencies to now take up the recommendations and start a much more intensive and rigorous enforcement process where they were going to be looking at the publicly available data and focusing on that. Justice Department, CFPB, other agencies was supposed to be looking at that. But of course, that has now all been sidelined. And so, again, I think that's a super important emerging issue. And I think we have to get to the bottom of this practice because I think it is predatory in the sense of taking advantage of Black communities. And it does have the same effect of stripping equity out of Black communities.
John, I'm so glad you brought up both of those points. One, on the taxes side of things, we did kind of do a dive into the historic context of Black property being assessed higher and kind of what that meant for Black communities, along with not receiving the same services despite paying so much in property taxes. And I think that's a fascinating subject to carry on into modern times, as we seem to repeat ourselves over and over again. Just simply the passage of time does not change practices. I think we could probably have an entire discussion still on the modern day practices that you've raised there. I think that's a great topic for us to circle back on. Same thing with the appraisal issues. There's a lot of historical context there. And you're right, that's very important. We've seen that occur even here locally. We've had stories in Jacksonville, a similar scenario with having to whitewash the house and getting a completely different result. And, when you look into the history of who's been appraisers and how that whole system works, is very, very interesting. So I'm grateful that you flagged those, and I do think we should have further conversations on those topics in the future. This really has been a great conversation. I want to thank you for joining us this week and sharing all your insight and your experience with us. It's been really, really great to chat with you.
It's been great to be with you. Thanks so much for having me.
Thank you for joining us this week in Last. We hope you enjoyed John's insights as much as we did. If so, give us a like and don't forget to follow CLS on Facebook, Instagram, and LinkedIn. Please also subscribe to the podcast so you always know when new episodes are released, and leave us a comment and share our information with your friends and family. And remember, if you or someone you know is experiencing housing discrimination, or if you would like to schedule a fair housing training, contact our Fair Housing Unit at 800-875-8785. To see if you qualify for other legal assistance, contact the CLS helpline at 800-405-1417. We're so glad you joined us this season as we rounded out our discussion on housing segregation and introduced the Fair Housing Act and some of the modern-day discriminatory practices advocates are fighting against. We'll be taking a break as we create more content on the Fair Housing Act, and we can't wait to return next season. We'll see you then.
The work that provided the basis of this publication was supported by funding under a grant with the U.S. Department of Housing and Urban Development. The substance and findings of the work are dedicated to the public. The author and publisher are solely responsible for the accuracy of the statements and interpretations contained in this publication. Such interpretations do not necessarily reflect the views of the federal government.